Thank you, Mr. President, members of the Tribunal. Good morning. It is a great honor and a privilege to appear before you on behalf of the Republic of Rwanda. Our opening submissions will be arranged as follows. First, I will begin with some introductory remarks on the nature of this dispute. Second, I will set out the relevant facts and take you through the main documents. Third, I will deal with Rwanda's case on the breach of the finance note and Article 18. Fourth, I will briefly respond to the United Kingdom's arguments on preclusion. And at that point, I will ask you to give the floor to Ms. McRae, who will deal with the final two sections in our opening submissions, the breach of Article 19 and remedies. Mr. President, members of the Tribunal, there are three introductory observations that I would like to make. First, the Rwanda-United Kingdom partnership has been the object of a lot of attention in the media. The focus of this attention has been almost exclusively on the perspective of the United Kingdom. Everyone knows why the United Kingdom chose to enter this partnership. The previous British government believed that the partnership with Rwanda would assist in addressing an urgent social and political challenge, illegal migration, especially the crossings through the Channel. That was the policy objective of the United Kingdom, which Rwanda understood and respected. But the United Kingdom did not get into the United Kingdom Migration Partnership. The partnership was, as we've heard, the Migration and Economic Development Partnership. Rwanda had its own policy interests and objectives, which deserve equal recognition and respect. As you've just heard from Rwanda's agent, Dr. Ugida Shebuja, Rwanda's objective was to integrate refugees into its economic development plan. That plan is set out in a document called Vision 2050, which is mentioned several times across the partnership. As part of that development plan, Rwanda wants to break with the traditional model of refugee protection and refugee assistance in much of the global south, a model that too often, as we heard, leaves refugees confined in camps, marginalized from the host society, and entirely dependent on humanitarian assistance. Instead, Rwanda wanted to emulate the best practice of successful advanced economies at times of great economic growth, such as Rwanda is experiencing now. And that practice is to integrate refugees in the social and economic fabric of the country, allowing their human capital to contribute to national development. And this required, among other things, the upgrading of the asylum adjudication system. Rwanda's refugee policy was grounded in extensive work undertaken over many years by international organizations, economists, anthropologists, and even lawyers who've been advocating for the kind of policies that Rwanda adopted. And by the way, Rwanda did not need the United Kingdom to be prompted into action on these matters. The May 21 joint UNHCR strategy with Rwanda was published almost a year before the April 22 Memorandum of Understanding between the United Kingdom and Rwanda. Anyone familiar with the complexity of international refugee protection will recognize that the 21 Rwanda-UNHCR joint strategy is one of the most ambitious, thoughtful, and progressive statements of refugee policy in the world today. And that was the strategy with Vision 2050 that Rwanda wanted to advance through the partnership. It is no surprise that having invested so much time and effort in this partnership and having so much at stake in it, Rwanda was deeply disappointed when the day after the British election in July 24, the new British Prime Minister declared that the Rwanda scheme was dead and buried. When he said that, he would have had British immigration policy in mind, but he was speaking as the new head of government. And Rwanda did not appreciate that tone. A few days later, it sent a note verbal to the British High Commission in Kigali, where Rwanda said, "We are a country, not the name of a scheme." And this takes me to the second introductory observation. Rwanda is not going to be drawn into an unnecessarily confrontational tone, but after all the time that was spent into this partnership, including by the various officials who worked on it, the United Kingdom's complete failure to comprehend Rwanda's perspective in this partnership is a matter of genuine regret. Rwanda understands that from the United Kingdom's perspective, the partnership was about British immigration policy. And in fact, this dossier was managed through the British Home Office, and even today, aside from Council, the delegation of the United Kingdom consists exclusively of officials from the Home Office. But the United Kingdom cannot look at this treaty that creates a partnership just through the prism of its own domestic politics, with Rwanda being little more than an instrument for delivering British policy objectives. It is, if I may, this rather inward-looking approach that explains the United Kingdom's rather tone-deaf response to Rwanda's case on Article 19 of the agreement. Article 19 obliges the parties to make arrangements for the resettlement of a portion of Rwanda's vulnerable refugees in the United Kingdom. As this tribunal will know, many countries run refugee resettlement programs. Rwanda agreed to receive some of the United Kingdom's asylum seekers, but among other things, it expected that in return the United Kingdom would honor its obligation to resettle a portion of Rwanda's vulnerable refugees. And yet, once the United Kingdom changed its domestic migration policy and decided it no longer wanted to relocate refugees from the United Kingdom to Rwanda, it appears to have assumed that it could simply disregard the obligation under Article 19 while it was still in force. Rwanda has taken a deliberately measured and reasonable approach in its request for relief under Article 19. We could have asked for more. We will hear what the United Kingdom has to say in response, but we respectfully submit that in the context of a treaty between an affluent state and a developing state, where the former also undertook binding commitments concerning vulnerable refugees in the latter, a response by the affluent state, marked by a completely unconvincing and somewhat disdainful formalism, warrants the strongest reproach by an international tribunal. The third introductory remark, Mr. President, and members of the tribunal, is that quite surprisingly, given what I've just said, we have detected a degree of manufactured outrage on the United Kingdom's part. We saw this in the Statement of Defence, and we heard some of it in the brief procedural hearing we had, when the United Kingdom complained that Rwanda had changed its case in the reply. The United Kingdom submitted that the fact of Rwanda having changed its case was a specific reason why its proposed approach to the timetable had to be preferred. And yet, just a few hours after making that submission, the United Kingdom informed the tribunal in Rwanda that it was not going to file a rejoinder, declining the opportunity to address Rwanda's allegedly new case in writing was an unusual step to take in the circumstances. It undermines the suggestion that there was any significant change, let alone one to be so outraged about. And incidentally, Rwanda has not changed its case. Rwanda's case was and remains that if you look at the two note verbals from November 2024, you do not see a binding agreement. And that's the case, and that has always been the case. We now have further context for that position as a result of the United Kingdom's disclosure of the documents in the lead-up to the November exchange, and as a result of the documents that we produced with our reply. There has been no rejoinder, and so as far as context goes, this is where we are, the documents that the parties have produced so far. And as we will see in the course of my submissions, that context does not detract from Rwanda's main case. On the contrary, it confirms it and it supports it. Mr. President, members of the tribunal, with these introductory observations in mind, what I would like to do next is to set out the facts by going through some of the main documents. The partnership, as we know, was signed on the 13th of April 2022. We do not need to turn up that document, but the reference is Exhibit C9. The Memorandum of Understanding from April 22 was followed by a non-binding finance note, which was concluded on the same day through an exchange of notes verbals. And the non-binding finance note from 2022 is in 3 different places, actually. You have it at C10, and that's the finance note from April. But later on in July, there was a further exchange on the 22 finance note because the United Kingdom spotted a typographical error in the previous version. So they went through an entire new exchange to correct the typographical error, which is quite interesting. It illustrates the importance of precision in identifying what parties have agreed. So the corrected exchange on the 2022 finance note is at C15 and C16. That's exhibit C15. And if we could take a quick look at these 2 exhibits. So C15 is the United Kingdom initiating note verbal. The arrangements are set out in an enclosed annex. The enclosed annex is identified clearly in the 2nd paragraph of C15. The United Kingdom refers to the financial arrangements for the Migration and Asylum Processing Partnership enclosed at Annex 1 to this note. The Annex 1 financial notes then follow. The Rwandan reply is at C16. And Rwanda's reply also refers to Annex 1 to this note. In paragraph 2, it identifies the initiating note verbal from the United Kingdom, both the one from April, which is the one that had the typo, and the subsequent one that corrects the typo, and then refers to the financial arrangements enclosed at Annex 1. In other words, it is completely clear, looking at this exchange in July 22, what the parties are referring to. The text being that in the annex, in annex enclosed, Annex 1 enclosed to this note. The parties also have, in the paragraph just before the courtesy paragraph, the language that is relevant to the November exchange, namely the proposal to place on the record the joint understanding of the 2 countries as recorded in the 2 notes, and the joint understanding taking effect on the date of the reply. The United Kingdom invites Rwanda to agree to that, and Rwanda agrees by repeating that language. So that's the non-binding exchange of notes verbals on the finance note. The other point I would make about the actual financial arrangements is that at paragraph 1.4, so you have this exhibit C15, and if you go to the annex, you see paragraph 1.4, which introduces the Economic Transformation and Integration Fund. That's what the parties have abbreviated as the ETIF. And it says that the ETIF was targeted at supporting Rwanda to achieve 2 national initiatives, Vision 2050, the National Strategy for Transformation. So this was the economic development pillar of the partnership, which is very much in sight and central indeed to the partnership, even when it existed in non-binding form. So we are in July 22 with the exchange of the corrected notes on the partnership. Work begins on implementation, as we've heard. Proceedings also begin in British courts, challenging the legality under English law of the relocation of asylum seekers to Rwanda. Those proceedings reach the Supreme Court of the United Kingdom. That Supreme Court delivers a judgment on the 15th of November 23, where it declares the policy unlawful. To address the legal problems identified by the Supreme Court, the British government, asked Rwanda to inscribe the partnership in a binding international agreement. Rwanda responded to that request promptly. Within only 3 weeks, the party signed the Rwanda-United Kingdom Migration and Economic Development Partnership on the 5th of December 2025. And the text of the treaty is at Exhibit C19. We also have the exchange of note verbals that records the entry into force of the treaty. The references are Exhibit R8 and R9. The treaty entered into force on the 25th of April 24. On April 26, so just the day after the entry into force of the treaty, the United Kingdom sent 4 notes verbal to Rwanda, which detail various arrangements under the treaty. And Rwanda sent its reply, note verbal, to each of these notes on the following day. These exchanges are at exhibits C47 to C54. We don't need to go through them because they're not issues relevant to the dispute. But it may be worth turning just to one exchange to see how arrangements under this treaty were put in place by the party, arrangements under different provisions of the treaty. So if I could please ask you to turn to C47, Exhibit C47. So this is where the United Kingdom proposes arrangements under Article 4 to 7 of the agreement. Articles 4 to 7 deal with the relocation of asylum seekers from the United Kingdom to Rwanda. And as you can see, the United Kingdom's initiating note verbal proceeds as follows. The United Kingdom proposes the following arrangements for the purpose of confirming our joint understanding of the meaning of Article 4 to 7 of the agreement. And the arrangements are then set out in the following pages. And following on from the arrangement, in this initiating note verbal, the United Kingdom proposes 2 things. First, that this note and Rwanda's reply to that effect will place on the record the joint understanding of the 2 governments, and second, that the understanding will come into effect on the date of Rwanda's reply. And then we have the courtesy paragraph, the signature, and the stamp. Again, the arrangements are very clearly identifiable. The final paragraph describes them as the arrangements set out above, and the paragraph that precedes the arrangement in the actual text of the note verbal, which is the second paragraph of the note verbal, says, I have the honor to propose the following arrangements. There can be no doubt, looking at this document, what the arrangements are. The Rwandan reply is at C48, and Rwanda's reply proceeds as follows. Rwanda acknowledges receipt of the note verbal, which it identifies clearly. Rwanda repeats in the first paragraph of its reply the purpose of the note verbal in terms that are identical to those of the United Kingdom. And it says, the arrangements sets out the joint understanding of the meaning of Article 4.7 of the agreement. And then in the second paragraph, Rwanda confirms that the above arrangements are acceptable and that this note, Your Excellency's note, place on the record the joint understanding which comes into effect today. So even a reader who is unfamiliar with the formalities of how states reach binding agreements through this process of exchange of note verbal, looking at this exchange would immediately know what is going on. That's what they are reaching a joint understanding on. And there is the question, is it binding, is it not binding? But for the time being, I'm just looking at how the 2 states were in practice managing their treaty relations and making arrangements under this agreement. And it's all fairly standard. There is nothing really unusual in this. We now come to May 2024. And this is when the parties exchange drafts on what became the 24 finance note, which the parties agree is binding. We have two documents on the record that show the parties' comments on drafts of the finance note. And if you could please turn up Exhibit C36. This is a draft that has comments from Rwanda. At paragraph 1.8, Rwanda requests that a clause that had featured in previous exchanges that describes the arrangements as non-binding is removed. And the comment by the Rwandan official is, we need to be able to enforce certain provisions, for instance, as it relates to the ETIF funding schedule. And the second comment to which I would like to draw your attention is at paragraph 6.1. No page numbers, but it's the comment next to paragraph 6.1. So here, Rwanda is insisting on binding dispute settlement under the 24 finance note, unlike its non-binding predecessor, the 22 finance note, which did not make provision for binding dispute settlement. And the comment by the Rwandan official specifically refers to two possible disputes that could arise. It says Rwanda not providing a refund in the event of termination, and the United Kingdom refusing to issue further ETIF payment without formally terminating the treaty. So both of the changes to which these comments refer were agreed and implemented by the United Kingdom. There is no dispute as to the content of the finance note and its effect. But I'm drawing these comments to your attention because they indicate that Rwanda was not only making it clear from the time when the finance note was being put together that he wanted to be able to enforce the rights under the ETIF, but also that suspending ETIF payments without termination could give rise to dispute. That they put it there in the document very early on. The note verbals on the actual finance note, as agreed, are at C22 and C23. I would like to make a few observations on the finance note. So if we look at C22, on the first page we have the cover note verbal from the United Kingdom proposing the following financial arrangements, and then in the following pages we have the financial arrangements. On paragraph 1.1 of the arrangements says the terms used in this note have the same meaning as in the agreement, a point on which we rely on the question of the meaning of the term year, to which I will come back in due course. Paragraph 1.5 replicates the language of the 22 finance note about the ETIF funding stream, and again you see the reference to Vision 2050 and the National Strategy transformation. Then at paragraph 2.31 we have the payment schedule and the payment obligations for 3 years with the dates when those payments are due to be made. If we then turn the page, at paragraph 3.1 we have the provision on amendments, which specifies that amendments may only be made by written agreement. And on the next page you have the provision on termination at paragraph 5. We rely, again for the question of the third year, on the second sentence of paragraph 5.2. So I'm just flagging that for the moment. The dispute that the parties have on the termination provision centers on that sentence. Then after the arrangements are completed, on the final page of the note verbal, we have the usual language. If the arrangements set out above are acceptable, this note will place on, the United Kingdom proposes that this note and the ministry's reply to that effect will place on the record the understanding of the two governments, which will come into effect on the date of your reply. Rwanda's reply to this note verbal is entirely standard in terms of the features of what one would expect. We see the references to the initiating note verbal, the subject matter being the financial arrangements, and we see Rwanda confirming that the arrangements are acceptable and then expressing its consent. That the two note verbals together place on the record the understanding, joint understanding on the matter, and confirming that the agreement is in force. Again, no one can have any doubt, looking at this exchange, at what is going on between these two parties. We now move to July 24, and I mentioned, and the agent, Dr. Rugashabuja, also referred to the note verbal that described, to the comment by the Prime Minister, British Prime Minister, describing the Rwanda plan as dead and buried. And I refer to the note verbal that Rwanda sent in response. You have it at C26. Rwanda says this note verbal is sent in response to the public statements made by the United Kingdom Prime Minister and the Home Secretary. Rwanda notes that no formal communication on termination had been received. It refers to baseless insinuations about its use of funds. And it politely but firmly asks the United Kingdom that the tone and substance of the interaction should reflect the state-to-state agreement that had been concluded and approved by both parliaments. And there are two things that are clear from Rwanda's first note verbal to the new British government. First, there had already been an erosion of trust between the parties. Rwanda clearly felt quite aggrieved. Second, Rwanda had no intention of being submissive. It would defend its interests firmly, and it could be expected and should be expected to assert its rights. On the same day, the United Kingdom sends a note verbal to Rwanda. You have it at Exhibit C28. In a rather roundabout way, the United Kingdom informs Rwanda that no further removals of individuals to Rwanda under the MEDP are scheduled or intended to be scheduled. I say roundabout because the note verbal says that it is informing Rwanda that the United Kingdom government has today informed the High Court. On termination, this note verbal says the UK government will be considering the issue of formal termination of the treaty under Article 23 in due course. So the message from the United Kingdom at this point is this was our policy before the election. We're no longer interested in that policy. We've changed our mind. We informed our courts. We're informing you, Rwanda, that we informed our courts. And as for the termination of the treaty, we'll just think about it in due course. Any party that is at the receiving end of this kind of communication, whether in a contractual or treaty relations, will just do one thing, which is wait and see what they're going to do next. But there isn't really anything in this note verbal that could have given Rwanda cause to feel any less aggrieved, or certainly to take any step. Now, the next chapter in the story is one where I'll need to spend a bit of time. These are the documents on which the United Kingdom's case appears to rest. And as I said at the outset, and I will be repeating this point, I'm afraid, because it is quite key, our case doesn't need these documents. All you need to decide this case respectfully is the two note verbals for November. They are a complete, they offer complete support to Rwanda's case. But we have these documents on the record. The United Kingdom has made a lot of them, so it is important to go through this context. I will also say that we have apologized in our reply for the fact that in our statement of claim we moved from the July note verbal to the November note verbal and omitted to mention in particular two notes verbal in September and October, as well as the communications that took place in that period. There was communication between the parties in the period that preceded the November 24 exchange. We wrongly suggested otherwise because clearly not all the documents had been located at our end at the time when we drafted the statement of claim. Rwanda and Council repeat that apology. But the documents have now been located and nothing else has come with the rejoinder, so the tribunal has all the documents that the parties, to the best of their knowledge, consider to be relevant to this dispute. So with that in mind, let us take a closer look at the September-October period. And let's begin with the notes verbal that we had omitted from our initial account. These are at Exhibit R13 and R14. These are notes verbal sent by the United Kingdom to Rwanda, asking for meetings for a visit of British officials, a delegation of Home Office officials to Kigali. The purpose of the visit is described as to discuss the logistics and timelines for the subsequent formal withdrawal of the United Kingdom from the Migration and Economic Development Partnership. And the other topics on which the British government wanted to have discussions are set out in the fourth paragraph of the note verbal at R13, which says, in parallel, we propose to convene a series of meetings to talk through and agree the ongoing provisions and support, including monitoring arrangements and relevant financial remuneration for the 4 individuals who accepted voluntary relocation to the Republic of Rwanda. We would also welcome the opportunity to hold further discussions regarding the longer-term future of those migrants from the British Indian Ocean Territory to whom the Republic of Rwanda has generously provided emergency medical treatment and who currently remain in Rwanda. So that's what the British government says it wants to discuss. The next note verbal at R14 is sent shortly before the visit and essentially repeats those points, and in particular the topics for the discussion. Next, we have an interesting document, one that has been produced by the United Kingdom. This is R15. R15 is a readout of the meetings that took place on the 3rd of October 2024 after the 2 notes verbal that I've just referred to. And if you look at R15, this is obviously an internal document. It's a readout sent by one official to other officials in the Home Office. And the readout begins by saying that we had a really positive morning of negotiations with the government of Rwanda. The paragraph under voluntarily relocated individuals says, the government of Rwanda confirmed that their intent was to continue building the asylum system, including the appeals body required by the treaty. And the readout continues, this means that all 4 voluntarily relocated individuals will remain in Rwanda under the terms of the treaty, which is the best case outcome, obviously from the British point of view. This matter is therefore closed. So these are British officials telling other British officials, we have solved it. We have solved this problem. So it is clear that Rwanda was not playing any games. It made its position entirely clear. Its policy aspirations had not changed. It remained committed to developing and strengthening its asylum system as part of its broader refugee policy. And so the individuals who had relocated to Rwanda could be assured that Rwanda would honor the partnership. Rwanda's continued implementation of the treaty therefore ensured that the 4 individuals were still protected under the terms of the treaty, as the readout makes it clear, and by confirming that those commitments would be maintained, Rwanda enabled the United Kingdom to regard the matter closed. The concern that the United Kingdom had was that if the treaty had somehow fallen away, Rwanda had not offered those assurances, the 4 individuals might have argued that the basis for their relocation to Rwanda no longer existed, and they might have sought return to the United Kingdom on the basis that they'd relocated to Rwanda on a false premise. And that's why this was an important issue, one that was identified in the note verbal and referred to in the readout. The problem is not the number, as I'm sure the tribunal realizes. It's not about the 4 individuals. The problem is the headlines. They just want to make sure that they're not going to get a headline about 4 individuals who had been sent to Rwanda by the previous government now coming back to the United Kingdom because something had gone wrong. So that's why they had to make sure that this issue was resolved. The problem is the headlines. And in a lot of this, the politics around this agreement, headlines are a primary concern. At the bottom of this email, you then see the reference to the ETF payment. Now, contrary to the United Kingdom's characterization in the statement of defense, we can immediately tell from the internal readout that the United Kingdom officials understood that Rwanda was just in a listening mode at that point. And there are a number of other things that are really quite clear from how those exchanges between the officials are relayed internally within the British system. First of all, we have that subject heading at the bottom of the email at R15. It is described as 50 million ETF payment due in April 25, diplomatic visa arrangements, airside transit visa waivers. It's just one item. Then we have that first sentence. As expected, these issues appear inextricably interlinked. We talked Government of Rwanda through the timeline for revoking the Safety of Rwanda Act in order to bring the treaty to an end, and the reasons for needing to do so in the way set out. We then made the case that our desire is not to do so and highlighted the risk of further negative media coverage of Rwanda that we wish to avoid. And let me pause here for a second. Rwanda was being told the United Kingdom to terminate the treaty has to do some legislative tidying up. If we do it in a standalone bill dealing only with the treaty, it will attract negative publicity for Rwanda. But if we drop this point in our big new bill on migration, which will take some time to put together, people are less likely to notice, and that is going to be better for Rwanda. With the greatest respect, Rwanda was unlikely to regard this argument as compelling, given what was at stake, but they listened to it, and the United Kingdom made its case. The note then says, Government of Rwanda appeared open to agree, and notes verbal confirming that all parties agree that no further ETF payments are due. However, they are clear that they would like to be added to the DVA list in spring. Specifically, they would like this to allow diplomats and those with a service passport, business to transit landside. Then in the next page, it says, they, the Rwandans, further asked to be added to the list of countries eligible for airside transit visa waivers. At present, Rwanda is listed in Schedule 1 of the Immigration Passenger Transit Visa. This means nationals of Rwanda are required to hold a visa to transit airside. So that's the very preliminary discussion that they have. The Rwandans are listening to what the UK has to say, and other items are discussed. All that this readout tells us, actually before I sort of summarize on R16. concluding two paragraphs are also quite important, because the official says, I think we therefore need a few things urgently in order to be able to ask the Home Secretary to make a decision. And the official then lists 3 items on which they needed some instruction from the British system or from the political level. Can those travelling on the service passport be included in the DVA as requested, or is it limited to diplomatic passports? Are there any issues with agreeing airside transit visa waivers? And third, could we set out the rationale for why some African countries are allowed to have airside transit visa waivers? This is a particular point of contention for the government of Rwanda. And the final paragraph says, once we have a clear position, we can formalize our position and seek to get certainty on whether it is agreeable to the government of Rwanda or whether we will need to introduce the Safety of Rwanda repeal in the next 2 weeks. That's the standalone bill. So at this stage, all we know is that there was an exploratory meeting. Rwanda was in listening mode. Rwanda raises a number of other issues that are of interest to it. The United Kingdom had yet to decide what to offer Rwanda. They had not reached the stage on October the 3rd of having really decided what to offer. And that's why the official presses the system to tell him, what offer can I make to the Rwandans? Because until we get to this stage, we simply cannot get certainty on whether it is agreeable to the government of Rwanda. So this is all very early days. United Kingdom understood that they couldn't simply expect Rwanda to give up its rights under the treaty while the treaty was in force, and happily agreed not to be paid 50 or 100 million. Why would Rwanda do that? Why would the United Kingdom ever think that that could be a sensible proposition? Well, the answer is they didn't. They were trying to see what offer they could make, to see whether something might be perhaps agreeable by the Rwandans. That's what the October the 3rd readout tells us. The United Kingdom still had to reach, as they put it, a position on what we are offering. A position on what we are offering. Now, the next document is C43. Now, this is an internal Rwandan document. This is an email sent 5 days after the meeting, to which the previous document referred. And it is an email sent from a Director General in the Rwandan Ministry reporting on her meeting with the British High Commissioner. And we see that from the second sentence, the High Commissioner informed me that after consulting London, the UK Home Secretary wishes to negotiate a diplomatic visa waiver agreement with Rwanda. In return, Rwanda would not seek any further payments under the MEDP. So that seems to be the kind of offer that the United Kingdom was contemplating. And the official says at paragraph 3, I asked for further details about the proposed visa waiver, and she clarified that it would apply only to diplomatic passport holders. The waiver would be biometric free, etc. And then the final paragraph, the official says, on the subject of transit visas, the High Commissioner confirmed that there would be no waiver except for existing exemptions, covering passengers transiting through the UK en route to the US, Canada, New Zealand, or Australia. She stressed that a broader transit visa waiver is not possible at this time due to an ongoing global review of the UK's visa system. So on the 3rd of October, when they have this very high-level discussion, they hear from the Rwandans that that's something that matters to them. The British officials record that as an important point for the Rwanda, and already by the 8th of October, the answer is you're not getting the transit visa. So this is C43. Then the next document is from the following day, and this is an email from the foreign minister, the Rwandan foreign minister, Ambassador Nduhungirehe, to other colleagues in the government, including the Minister of Justice here next to me, to set up a meeting to discuss a request from the United Kingdom that we do not pursue the third 50 million payment in exchange for a diplomatic visa waiver agreement with Rwanda. That's what they understood the United Kingdom was essentially tentatively putting on the table, that kind of discussion. Now, following on from this, on the 10th of October, there is a call between the British Home Secretary and the Rwandan Foreign Minister, and we have both a United Kingdom and a Rwandan contemporaneous internal account of this call. The accounts are not entirely consistent, in essence because the United Kingdom account appears to suggest that more progress had been made than the Rwandan account. The readout on the British side is at R16. So this is a readout that is shared between, as far as I can see, officials, so not something for the political level, I think. And it suggests that Rwanda, the United Kingdom had understood that Rwanda might sign a note verbal removing the obligation to pay the ETIF funds. There are two further things that are clear, even from this internal UK account. First, this was a best progress in a discussion which was still very much in the early stages. And indeed, the final paragraph confirms that no text had even been proposed at this stage. So they're just still trying to discuss some framework for a possible framing of the negotiations. Second, the email, the readout, again notes that the step of the note verbal had been that this step in the discussions had been reached alongside the United Kingdom making some offer on diplomatic visa arrangements. So there's two bullet points where the internal note says it was agreed that government of Rwanda would sign a note verbal, the first bullet point, and the second one, we would extend diplomatic visa arrangements. So that's how the United Kingdom sees those discussions as of the 10th of October. On the next day, we have another internal email between officials that the United Kingdom has chosen to disclose. And this is an email that from one Home Office official to another, which summarizes the officials' understanding of the progress that had been made as follows. We anticipate that we will no longer need to bring forward the bill repealing the Safety of Rwanda Act next week, subject to signing the note verbal. That's how they summarize the position internally on the 10th of October. The officials understood, of course, that unless they thought what they thought might hopefully be signed was actually signed, there was nothing. And we do know, by the way, that the following week nothing was signed because we're still on the 10th of October. And so if the United Kingdom, having reached that decision point referred to in this email, chose not to go forward with its domestic legislation, that's the United Kingdom's choice, and it is their risk. It's not a matter for Rwanda. I said there was a Rwandan account that slightly differs. We have it at C42. So if we could turn to C42 now. Now the difference between the two documents is that R16 is an email between officials who are updating other officials on the dossier, whereas Exhibit C52 is an official note of the call that is taken by Rwandan civil servant. It says this. So this is a note of the call with the British Home Secretary. This was the second call they had. It refers to a previous call on the 10th of July, which doesn't seem relevant to the dispute because we don't have a readout of that. At paragraph 4, we can see that the Rwandan minister was predictably non-committal. He refers to saying that Rwanda will, in principle, not pursue that payment provided that the UK follows the right legal procedure. So all the necessary caveats are there. And this note also records that a draft would be sent by the United Kingdom the next morning to Rwanda. So they're still discussing at a fairly high level. And paragraph 5, we have the points that Rwanda raises, or rather the points that the United Kingdom hopes might persuade Rwanda into a binding exchange. So we have a reference again to the visa waiver, diplomatic visa waiver, and the British Home Secretary says the UK is willing to facilitate visa waivers for up to 100 diplomatic passports per year. On the next page, at paragraph 6, we can see that the Rwandan minister is not that impressed with what he's heard in terms of the United Kingdom offer. He appreciates the progress on diplomatic visa arrangements, but expressed interest in doing more and making further progress on broader cooperation and long-standing matters. And the minister also noted that the United Kingdom is the only country in Europe that has yet to prosecute or extradite genocide fugitives. And then the next step was going to be the sending of this draft by the United Kingdom. I should have said before, paragraph 7, the Home Secretary, British Home Secretary, says the UK is open to further discussions in all these areas except on transit visa. So they closed the door to transit visa, which had come up as a possible element in the package on the 3rd of October. By the 10th of October, they drop it. But they still say that they're open to further discussions on other matters to try to get the Rwandans to agree to the position that the United Kingdom would wish them to agree on. What follows the ministerial call on the 10th of October are exchanges between officials throughout October. The United Kingdom places great reliance on these exchanges, and I've already explained why they are really not in any way determinative. But what they show, and I'll go through some of them, is that everyone on the British side fully understood after the 10th of October, as well as before, that different steps had to be completed. First, officials had to discuss and finalize some text. Second, that text had to be taken to the political level for approval. And third, the text had to be properly exchanged and signed. And the fact is that in spite of the United Kingdom investing a lot of time in trying to persuade the Rwandans, what becomes clear by the end of October is that the parties cannot even complete the first stage in the process. They cannot even finalize a text between officials. So that's how far they get to through these October discussions. And so unsurprisingly, what happens later in November is that the texts on which the officials have been working throughout October are just jettisoned, they're abandoned, and the new approach is adopted. And I'll come to that new approach because insofar as we need to look at the preparatory works of those two notes verbal, it's actually what happened in November that is more important than what happened in October. Because in October, they're discussing drafts that were just abandoned. Well, let's take a look briefly to set out the facts in full at the exchanges in October. So the first document here is C45. This is an email sent on the same day as the call between the Rwandan Foreign Minister and the British Home Secretary by an official at the Home Office to a Director General at Rwanda's Ministry of Foreign Affairs. And the official says, please see attached informal note from the Home Office with more details about the diplomatic visa agreement that we discussed with you on Tuesday. Apologies for sending so late, but hopefully still helpful ahead of the call. It may be worth caveating that these are details of the offer that could be agreed subject to the outcomes of discussions between our ministers tonight. They use, interestingly, similar language that the Rwandan ministers appear to use. Could be agreed, subject to. They're just discussing something. The DVA offer is follows in that same exhibit C45. This is a document that was attached to that email. It is described as DVA offer to the government of Rwanda. It refers to a new UK-Rwanda diplomatic visa agreement. It mentions at bullet point 1 that Rwanda would be offered access to a new diplomatic, UK diplomatic visa product, which is currently open to only 5 countries: China, Turkey, South Africa, Indonesia, and Vietnam. So the United Kingdom is saying, you will join this exclusive club. It's one of the things that we'd like you to consider as we try to make progress on the notes verbal. And here they're trying to come up with a proposal that is a little bit more granular. Now, so this is the DVA offer on the 10th of October. Let's now go back to the attempt to get some text on these note verbals, because that starts on the 10th of October after the ministerial calls. And we need to go to R18. So on October 11th, which was a Friday, the United Kingdom sends a draft note verbal with this accompanying note. The changes are relatively minor. We would aim to sign it today. So that's their follow-up. Please sign today. Here's the note verbal. Well, the Rwandans don't sign that document on that day. What follows from the Rwandans is actually an email on Friday, which you have at R20, where the Director General at the Ministry of Foreign Affairs says, could you please highlight the changes that were made, possibly in track changes mode? She wants to obviously see what is being proposed. Now, if you look at the draft that the United Kingdom sent, asking for it to be signed pretty much immediately, you have it at R19. It is clear from a quick look at this first draft that the United Kingdom signs in the vain hope that it sends in the hope that it would be signed immediately, that from a purely technical point of view, this was just the wrong draft. And if you look at R19, paragraph 1.3, for example, it says, the note confirms the parties' joint understanding of the commitments in prospects of formal termination of the agreement, including financial arrangements. It just isn't quite clear or in line even with what had been at a very high level discussed on the calls. At paragraph 1.6, this first British draft says that the note would amend and replace in entirety the note, the 24 finance note. Then at paragraph 1.1, the note was not going to be binding. At paragraph 2.1, under this draft, the United Kingdom was giving formal notice to Rwanda that the Memorandum of Understanding will be terminated. The Memorandum of Understanding wasn't the document that they were discussing. So there was complete confusion on the Rwandan side when they received this document. From a purely technical point of view, the official that looked at it didn't quite understand where it went. And so she asks for a track-changed version immediately. We then have, at R21, a rather apologetic email from another British official who apologizes because the whole thing about the changes being minor, please sign today, was a bit of a mischaracterization as it was accepted. The official now admits my email to another Home Office official was incorrect, as the changes between the two note verbals are quite significant, and we've entirely removed the ETIF payment. It is very important to us that you're happy. So the tone changes a bit because they realize that that approach of just please sign today on huge changes wasn't going to work. But let's say that things did not get off to an easy start from these very first attempt to discuss some drafts. Now, at Exhibit 22, the Rwandan official who had asked for a track change version of the document, replies and says the note verbal introduces significant changes that raises concerns for us and diverge considerably from our previous understanding. Now, the United Kingdom makes a lot of the draft that the Rwandan official sent and attached to this email on the 15th of October. And there are a few points I would make to just explain why that reliance by the United Kingdom is completely misplaced. First, this approach to the drafting of the note verbal was completely abandoned. It's not what tells us what went into the final text. Second, as we saw, the Director General who replies to this message had received a draft that made no sense technically. She's not expressing approval or agreement to anything. She's just trying to produce a draft that, in a technical sense, might work. None of these officials, of course, was in a position to provide final agreement on behalf of the state. And as we saw before, the British official who sends the diplomatic visa waiver agreement, which could be agreed subject to the conversation, wasn't in a position to agree on behalf of the United Kingdom to that diplomatic visa waiver agreement or even the principles behind it. I also note that when the draft is sent on the 15th of October, it's still only 5 days after the call, with this DVA offer still in space somewhere, put on the table by the United Kingdom. So that's an attempt by the Rwandan official to progress things technically. What we have next is another redrafting exercise by the United Kingdom officials on the basis of the Rwandan draft, and you have it at R25. And it's another draft. I don't need to go through these drafts because, as I said, they're not really relevant, but you can see from R25, just from the track changes, all the various things that have been amended to the text that had been, the draft that had been sent by the Rwandan official before. Now, things are not obviously making progress, and so on October the 22nd, the British High Commission writes to the same Rwandan official, and we have that email at R26. And the British High Commissioner refers to some discussion that they had before, and which had led the United Kingdom to removing most of the changes that appeared in that previous message. And the High Commissioner fully understood, this is the 22nd of October, that officials had not even reached the stage of a provisional text ready to be taken to the political level. They were not even there yet. And so the High Commissioner says in this email, I appreciate that you will now want to share with your colleagues and discuss further, but can I have a sense of timeline? And then, moving on with the chronology, on October 30th, we have an email from the British Home Office to the permanent secretary of the Ministry of Rwanda, which is at R28, but it's in the second page of R28. So it's the email at the bottom of the chain. And this email is sent on the 30th of October, and it says, our Home Secretary is very keen to get this agreed as soon as possible due to legislative pressure here in the United Kingdom. So this shows that as late as October 30th, the United Kingdom realized that nothing had been agreed. Moreover, what is also clear from the October discussions is that they, as they move along, is that at one point, from the second half of October, all that the United Kingdom seems to be doing is to put pressure on Rwanda. The reference to the offer that had to be discussed with Rwanda, and which the British officials at that first meeting on the 3rd of October had quite wisely identified as key to unlocking any chance of reaching agreement, that reference disappears from the second half of October, even though it had been seen as inextricably linked at the beginning of this process. The United Kingdom understood at the beginning that this process was going to be transactional, that there had to be some offer, some quid pro quo, and then maybe there could be some new agreement. But a few weeks into these discussions between officials, the United Kingdom decides to just apply pressure to get it over the line. The strategy at this point, frankly, seems to be a bit like the strategy of a salesman who, having realized that he's not going to get the deal that he wanted, just starts saying, please, please, sign on the dotted line. Well, Rwanda doesn't sign. There's not even a document to sign because they can't finalize a text that could be readied for signature. So all of this anxiety from the British system to get this over the line is noted in their internal documents, but ultimately it doesn't produce any agreement or even anything that could have been the subject of an agreement. So we're now on the 30th of October, and things really haven't moved in a helpful direction for the United Kingdom. We then come to November 24, and this is where we have the change of approach. There was a meeting on the 6th of November between the Rwandan Foreign Minister and the British High Commissioner, and as a result of that meeting, the United Kingdom decides it will change the approach. And this is how the United Kingdom describes the new approach to Rwanda on the 6th of November. If we go to R29, this is an email from the Deputy High Commissioner to Director General at the Rwandan Foreign Ministry. And it says, please see attached copies of the two new proposed documents from our UK Home Office colleagues, a short political note verbal and a technical annex to the note verbal, which, as Ali explained, covers the things we need covered for our legislative process. That's how the new approach is described by the United Kingdom, a short political note verbal and a technical annex that we, United Kingdom, need. This is, of course, a complete change from what we saw before. The previous drafts, which never got to the stage where they could be sent to the political level for consideration, were abandoned. Those previous drafts had tried to do more legal things with the text. And second, this new approach is described as a short political note verbal, whereas the previous discussions were about legal amendments. What must have happened is that the United Kingdom realizes there is no prospect of agreeing on legal amendments, and so it suggests a political approach. The United Kingdom on the 6th of November says that it will produce a draft based on the new approach. And we have the draft produced by the United Kingdom at R34. So this is what the United Kingdom would like under this political, it's at R30, I think. Yes, it's at R30, Exhibit R30. The text that the United Kingdom proposes says, it is hereby agreed that no further payments will be made under the Economic Transformation Development Partnership Agreement. The diplomatic agreement is underpinned by the annexed technical notes. So, that's the text that they put on the table for discussion. There is then a meeting on the 7th of November between the British High Commissioner and the Rwandan Foreign Minister to discuss a range of issues. We have an internal United Kingdom document, which is a readout prepared by an official. And in the final page of this document, the comment by the official is, The minister was a little non-committal on exactly what he wants to see from the Migration Partnership Note Verbal, although the British sense was that the challenge had been getting his attention. The key thing is that even internally they realized on the 7th of November they hadn't got anything in the bag yet. The minister was being non-committal. Then on the 12th of November, Rwanda sends a revised text. And the revised text is the one that you find at R36, and which is then the basis for the exchange. And the key features of the revised text sent by the Rwandans are these. The language of "it is hereby agreed" and diplomatic agreement, which the United Kingdom had put in its draft on the 7th of November, even though it had characterized the note verbal as political, that language is gone from the Rwandan draft. It is instead replaced with the language that we have in the November exchange: the United Kingdom respectfully requests. As we noted in our reply in the Statement of Defence, the United Kingdom says throughout formally requests, but it is respectfully requests. The technical annex, which the United Kingdom had said was needed for United Kingdom purposes, no longer underpins an agreement, which was the United Kingdom language. It now supports a respectful request. So a big change in what the Rwandans sent to the United Kingdom and what is eventually in the text of the note verbal. And these changes suggested by the Rwandans are entirely consistent with the fact that this was now a political note verbal, and they were not going to go for anything more. And it couldn't have been clearer from the exchanges that had taken place. Now, the November note verbals, and it took a while to get to those, but we had to deal with all this history that the United Kingdom says is relevant, are at C29 and C30. And this text is the one that has the language that you will be familiar with, that we've seen before. The government of the United Kingdom respectfully requests that the government of Rwanda forego any additional payments. This request is supported by the annexed technical note verbal. The annex was not an integral part of this note verbal. The signature and the stamp of the British High Commission are at the bottom of the note verbal here. And the entire approach suggests a political approach, and at most a technical annex that could have been the subject of some further discussions, but not something that even the initiating note verbal was putting on the table for agreement there. So even before we look at Rwanda's reply, we can already tell from the initiating note verbal that this is not the kind of initiating note verbal that can lead to a binding agreement. Now I'll come back to the to this text later, but just on the Rwandan reply, we have it at C30. Rwanda refers to the United Kingdom's note verbal. The date is wrong, but nothing turns on that error. And it refers to the request to forego the payments, to forego the ETIF payments. No reference is made to the technical annex. The UK request, the United Kingdom request is noted, but unlike previous exchanges, there is no reference in the initial paragraph to any joint understanding. We see no language of amendment, acknowledgement, or agreement in the Rwandan reply. There is a reference to proposed arrangements that are described as acceptable, i.e. capable of being accepted. And then the key thing on which I will make legal submissions is the absence of any language that expresses consent to be bound by the two notes verbal taken together with any language that expresses agreement to the exchange coming into force or into effect. And so the Rwandan reply is in sharp contrast with anything we have seen before and anything one would usually see in the practice of states on the matter of concluding agreements or memoranda of understanding that are not binding through this process. Now, before coming back to the note verbals and making the legal submissions, I'll say a few words about the subsequent conduct, just to complete the facts, because the United Kingdom places great reliance on subsequent conducts. And there are 5 documents that matter here, really, for subsequent conduct. The first one is an email at R39. So, there are 5 documents on which the UK relies in its subsequent conduct case. So R39 is a Home Office official writing to the Permanent Secretary of the Rwandan Ministry where he says, thank you. We now have the note verbal signed and agreed. This is an email from a British official which receives no response, saying to another one, thank you, and then describing the note and saying the note verbal had been signed. But it has absolutely no weight as subsequent state practice. It cannot be said to be the evidence of mutual understandings in relation to the exchange. We then also have some WhatsApp messages that the United Kingdom has included as part of its case on subsequent conduct. And you have those at R40 and R41. These are WhatsApp messages between the British Deputy High Commissioner and the Director General at the Rwandan Foreign Ministry, who's been involved in quite a lot of this correspondence, Miss Grace Nina Wumuntu. And the WhatsApp messages are mainly messages initiated by the Deputy High Commissioner, who says that she wants to check in on 2 quick things. She sets out what she wants to check in. I mean, one of the things is the 20 million payment, which was connected with the relocation. And then she refers to the Home Office colleagues visiting Rwanda, and again raises the question of the 4 volunteers, and asks, who should we meet on the Rwandan side to discuss these matters. And between, at R41, you have the second page of the WhatsApp message, and that's where you have the reply from the Rwandan official. She sends 4 brief messages between 9:19 a.m. and 9:22 a.m. on the 20th of January 2025, saying, hi, I'll just confirm on the question of who the meeting should be with, essentially, and then she confirms the 3 departments that should be involved in those meetings. So that's the WhatsApp message on subsequent conduct, allegedly. The next document that we have is at R42. Again, this is another email from the Deputy High Commissioner to someone in the Rwandan Ministry of Foreign Affairs, and the United Kingdom says there is no mention of the ETIF payment. It's an email from one official to another, and Britain doesn't mention the ETIF payments. It goes nowhere as subsequent practice. And finally, we have the 5th document, which is the note verbal sent by Rwanda on the 25th of February 25. And you find this at C31. It is a document that we had already identified as relevant. Now, this is the note verbal where Rwanda says that the ministry has, it's C31, second paragraph, the Ministry of Foreign Affairs now has the honour to inform the High Commission that the proposed arrangements as outlined in the technical annex to Note Verbal are not acceptable to the government of the Republic of Rwanda. As a result, the previous arrangements in the aforementioned Note Verbal are hereby rescinded. The United Kingdom's case centres on the use of one word in this document, rescind. That's their case on this document. And the United Kingdom says that this proves that Rwanda knew that the exchange was binding. However, the use of the word rescind proves nothing of the kind. In fact, in anything, it proves the opposite. If, as the United Kingdom contends, the November note verbals were a legally binding amendment of the 24 finance note, then Rwanda would have known that the only way to amend what had been agreed was another agreed amendment. Well, of course, Rwanda would have known that. If it wanted to change an agreed amendment, it had to have another agreed amendment. It wouldn't have proceeded on the basis that it could just rescind, so to speak, the amendment. In fact, it is entirely consistent with the political nature of the November note verbal, as stated by the United Kingdom at the time, that in February 25, Rwanda says, what may have been acceptable in November in a political sense is no longer acceptable. We take that back. It is rescinded, withdrawn, revoked. There are a number of words that one could use to describe what Rwanda was telling the United Kingdom at this point. But the use of the language of rescission does not have any particular significance. One can rescind a non-binding instrument. There's no reason why that word could not be used in connection with a non-binding instrument. The practice on subsequent conduct includes this one note verbal from Rwanda, where all the focus is the word rescind, and then there's 4 WhatsApp messages from the Rwandan officials between 9:19 a.m. and 9:22 a.m. That's the Rwandan conduct that the United Kingdom's case on subsequent conduct, in this case, rests upon. The other documents on which they rely are emails from British officials saying things in one way or another. Now, just to complete on the facts, and then perhaps it might be an appropriate time for the break. In December 24, so just taking a step back, the United Kingdom sent a note verbal on its visa arrangements to Rwanda, and we have it in C46. So this is sent after the November note verbals, and it is clear from a quick look at this note verbal that it is setting out in rather general terms various processes for visa services in the United Kingdom, but it is not really setting out the DVA offer from October the 10th. So whatever offer that British official on the 3rd of October had in mind as necessary to unlock this discussion never really went anywhere. And so that is the context that explains why we have the exchange that we have, and to which I will return and make legal submissions after the break, if that's a convenient moment.
Thank you, Mr. President. It is an honour to appear before you on behalf of the Republic of Rwanda. So that brings me to the entirely different subject of the United Kingdom's resettlement of refugees in Rwanda, from Rwanda. My submissions on this subject will proceed in 3 stages. First, I'll make some short remarks about the legal framework. Second, I will address Rwanda's case on breach of the relevant obligations. And third, I will address reparation. I will then make a few brief remarks about reparation in respect of the breaches of Article 18 and the Finance Note. So let me then start with the legal framework. The parties' obligations were recorded in Article 19 of the agreement. Members of the Tribunal, I invite you to turn to that agreement, which is at Exhibit C19, and to turn to Article 19 in particular. It is entitled Resettlement of Vulnerable Refugees. In similar terms to Article 18, Article 19 provides that the parties shall make arrangements. However, in Article 19, the parties had something more specific in mind. The arrangements are for the United Kingdom to resettle a portion of Rwanda's most vulnerable refugees in the United Kingdom, recognising both parties' commitment towards providing better international protection for refugees. Rwanda's claim is focused on the duty to negotiate to make resettlement arrangements in Article 19. As we record in paragraph 51 of the reply, there is a great deal of common ground between the parties, both as to the existence and the content of this obligation. And there are 2 points that are of particular relevance to Rwanda's claim. First, the parties agree that they are obliged to negotiate in good faith with a view to reaching agreement on the relevant arrangements. The United Kingdom's agreement with that proposition is recorded at paragraph 178 of the Statement of Defence. And second, the parties agree that they will discharge this obligation if they are proved to have made genuine efforts to advance discussions on the arrangements. This is agreed at paragraph 181 of the Statement of Defence. Mr. President, members of the Tribunal, there are 2 points that deserve emphasis. Not all obligations to negotiate are the same. Rwanda says there is a spectrum. At the one end, there is an obligation to negotiate without anything more. At the other end of the spectrum, there is an obligation to negotiate to achieve a precise result. For example, to negotiate on a specific agreement or on a specific subject matter. Article 19, we say, is at the latter end of that spectrum. The arrangements that the parties had a duty to make were for the United Kingdom to resettle a portion of Rwanda's most vulnerable refugees in the United Kingdom. That language makes the essential content of the parties' intended agreement very clear. The United Kingdom was to take a portion of a particular category of Rwandan refugees. Now, this can be contrasted with Article 18, where the only description of the parties' objective is that the arrangements had to be financial in nature, without any more granular description of which party would pay and for what purpose. That brings me then to my second point. While both parties were equally obliged to negotiate towards this result, it was clear in the end that the result was one that placed a burden on one party alone. Under this provision, it was the United Kingdom that was to take refugees, not Rwanda. That result was agreed. The burden was thus squarely placed on the United Kingdom. But as I will come on to explain shortly, the United Kingdom shirked that burden. It took no steps whatsoever to operationalise Article 19. Rwanda's claim, as I've said, focuses on the negotiation obligation in Article 19. Rwanda's claim is that the United Kingdom breached its duty to negotiate by failing to engage in any meaningful discussions about resettlement arrangements, which had the effect of precluding the achievement of the result prescribed under Article 19. I will now turn to that breach. Rwanda's case rests on 2 pieces of correspondence exchanged between the parties. The first is a letter from Rwanda to the United Kingdom, dated 24 March 2025. The second is a responsive letter from the United Kingdom to Rwanda, dated 1 April 2025. This correspondence establishes 2 things. First, that Rwanda sought to negotiate the arrangements for resettling refugees with the United Kingdom under the auspices of the Joint Committee. Second, that the United Kingdom refused to take any steps under Article 19, whether to negotiate arrangements or otherwise. I'd like to invite the Tribunal to turn to the first of those pieces of correspondence, which can be found at Exhibit C33. Members of the Tribunal, you will see from the first page of the exhibit that this is a letter dated 24 March 2025 from the Rwandan Ministry of Foreign Affairs and International Cooperation to the United Kingdom's representative as co-chair of the Joint Committee. Now, the Joint Committee was established under Article 16 of the parties' agreement. It was composed of representatives of both parties. Its role was set out in Article 16(2) of the agreement. That role included monitoring and reviewing the application and implementation of the agreement. It also provided a forum for the parties to exchange information and to resolve issues of a technical or administrative character. If I could then invite the Tribunal to turn the page, the Tribunal will see a heading, number 2, entitled Resettlement of Vulnerable Refugees Hosted by Rwanda to the UK. The letter commences by observing that Rwanda currently hosts over 130,000 refugees. Members of the tribunal, if you could then pick up that letter at the bottom of the page with the final paragraph commencing under Article 23 of the agreement. That, I should say, is clearly intended to be a reference to Article 19 of the agreement. If I could ask the tribunal to read that paragraph and the next paragraph over the page, I'd be most grateful. Mr. President, members of the tribunal, allow me to highlight the following features of these paragraphs. The first feature is that Rwanda begins by referring to the United Kingdom's ultimate obligation to resettle a portion of at-risk refugees from Rwanda. This is clear. Resettlement, after all, is the object of the arrangements which the parties had agreed to negotiate. The second point is that Rwanda then observes in the final sentence of that paragraph that the United Kingdom has failed to take any concrete action to fulfil its obligations under the agreement. As the United Kingdom accepts, its obligation at that stage was the obligation to negotiate with a view to making the resettlement arrangements. Rwanda was criticising the United Kingdom's failure to take any steps under Article 19. That included the negotiation of the arrangements, which necessarily predated those arrangements being made. The third point is, against that background, Rwanda then demanded that the Joint Committee urgently finalise arrangements for the resettlement of these refugees. Rwanda, we say, thereby recognised that there was a process to be undertaken. That process obviously included bilateral discussions, without which the arrangements could not be finalised. The fourth point is that Rwanda specifically invited the United Kingdom to comply with its international responsibilities. Rwanda was not simply asking the Joint Committee to act, but the United Kingdom itself. The fifth feature that I would identify is that Rwanda then invited the United Kingdom to attend the Joint Committee meeting with officials who were involved in the negotiation and drafting of the agreement, as they had the necessary expertise to resolve the matter. This gives further support to the idea that Rwanda had negotiations in mind. Taking those points together, Rwanda says that it is obvious that it was demanding the United Kingdom to participate in the activity that was necessary for the arrangements to be finalised, namely discussions as to the specific content of the arrangements. The United Kingdom's position is that Rwanda's request in its 24 March letter was not a genuine attempt to negotiate. We see this in the Statement of Defence at paragraph 193. It says this for two articulated reasons. The first is that Rwanda was making an accusation that the United Kingdom had breached Article 19 in the context of commencing the dispute settlement procedure under Article 22 of the agreement, not in the context of an attempt to negotiate. Now, it is of course right that Rwanda was seeking to raise the issue of the United Kingdom's conduct in respect of Article 19 with the Joint Committee for the purposes of Article 22. As Rwanda saw it, the United Kingdom had failed to take any steps in the 3 years that obligation was extant to meet its obligations under Article 19. But we say that context does not matter. This is because the relevant paragraphs of the letter were more than a complaint about the United Kingdom's conduct. They also contained an express demand that the Joint Committee finalise arrangements and that the United Kingdom comply with its legal responsibilities. The second reason that the United Kingdom gives as to why this is not a genuine attempt to negotiate is that the Joint Committee did not have the power to finalise arrangements. Again, we say this is beside the point. The obligation was on the parties to the agreement, Rwanda and the United Kingdom, to agree resettlement arrangements, not the Joint Committee. Rwanda's reference to the Joint Committee was simply a reference to the forum in which its request was being raised. As we explained in our reply, it was the right and appropriate forum. The Joint Committee, as I've explained, was the body that monitored and reviewed the implementation of the agreement, and it was comprised of representatives of both the United Kingdom and Rwanda. Therefore, neither of the United Kingdom's reasons as to why Rwanda's demand was not a genuine request to negotiate holds good. That brings me to the United Kingdom's response to Rwanda's letter. It is on this letter we say that the Tribunal should principally focus. Members of the Tribunal, I invite you to turn to that letter, which you can find at Exhibit C34. You will see that this is a letter from the UK Home Office, in particular from the United Kingdom's co-chair of the Joint Committee. It was addressed to the Rwandan Permanent Secretary, who is the Rwandan co-chair of the Joint Committee. It is dated the 1st of April 2025. The third paragraph of that letter is relevant to Rwanda's claim in relation to Article 19, commencing with the words, "with regard to Article 19 of the agreement." Again, I'd be very grateful if the Tribunal could read that paragraph in full, continuing over the page. The parties differ as to whether or not this letter establishes a refusal on the United Kingdom's part to take steps under Article 19. Rwanda's position is that it clearly did. Mr. President, members of the Tribunal, allow me to emphasise 3 points. The first is to recall the context for this paragraph and this letter more generally. It is responding to Rwanda's letter of the 24th of March, in which Rwanda criticised the United Kingdom for failing to take steps under Article 19, demanded the Joint Committee to finalise resettlement arrangements, and urged the United Kingdom to comply with its legal responsibilities. The second point is that the United Kingdom asserted that it was under no binding obligation to resettle refugees from Rwanda, as no arrangements had been made. Now, Rwanda accepts that the United Kingdom was only obliged to perform the arrangements once they had actually been agreed. However, it must be borne in mind that the United Kingdom had already accepted that it would resettle a portion of Rwanda's most vulnerable refugees in the United Kingdom. This, as I've explained, was a specific result to which the parties' arrangements were directed. This passage of the letter overlooks the binding obligation that the United Kingdom did have, which was to negotiate and conclude resettlement arrangements. This obligation, as the United Kingdom has positively averred, was not time-limited. It remained in existence even though Rwanda had initiated the dispute settlement procedures under Article 22. Indeed, it was to subsist for another 12 months after this letter was written. But in this letter, the United Kingdom says nothing about this obligation. By its silence, the United Kingdom appears to deny that it was subject to any relevant obligation at that stage under Article 19. The third and most important feature of this paragraph is that the United Kingdom referred to its note verbale dated 8 July 2024. It notified Rwanda that no removals were scheduled and that the United Kingdom intended to terminate the agreement. The United Kingdom then went on to confirm that steps were being taken to terminate and no further individuals would be relocated. Members of the Tribunal, these were very well-known facts. The only reason to draw them to Rwanda's attention in this context was to signal that the United Kingdom did not wish to progress matters under Article 19 in circumstances where the MEDP was being brought to an end. As noted by Lord Verderame before, the United Kingdom was so focused on its own interests that it seemed to assume that its disinterest in relocating individuals to the UK simply switched off Article 19. This is obviously an untenable interpretation of the agreement. The obligation was still very much in force. Rwanda says that it is clear from this passage that the United Kingdom intended to take no step whatsoever under Article 19 because it considered that there was a connection between its decision to terminate and no longer relocate individuals to Rwanda and Article 19. Members of the Tribunal, for those reasons, Rwanda says that by this letter, the United Kingdom breached its obligations to negotiate resettlement arrangements, as was required by Article 19. That then brings me to my third topic under the heading of Article 19, which is reparation. As with Article 18 and the Finance Note, Rwanda seeks declaratory relief in respect of Article 19. If the Tribunal finds a breach of Article 19, this remedy is not understood to be controversial. What is controversial is Rwanda's further request for compensation, alternatively an apology, and I'll address each in turn. First, to compensation. The parties are largely agreed on the relevant legal principles. As a starting point, it's common ground that the purpose of reparation is to wipe out the consequences of the illegal act and to re-establish the situation that would, in all probability, have existed had the act not been committed. It is common ground that Rwanda must prove a causal nexus between the wrongful act and the injury. It is also common ground that the precise scale of the damage may be approximated when there is uncertainty. Rwanda's approach in this case is to identify the number of individuals that would have been resettled under Article 19 had the United Kingdom complied with its obligations, and to identify the basic cost to Rwanda of those individuals remaining in country, at least in the first instance. The United Kingdom does not appear to take issue with the logic of that approach. Instead, it criticises the precise figures that Rwanda has used. So let us turn to have a look at those. Rwanda seeks compensation in the very modest sum of £6 million. To put this in context, this is 7% of the UNHCR's budget for Rwanda for 2025 alone. This sum is the product of an estimated 300 resettled individuals multiplied by a cost to Rwanda of £20,000 per individual. These figures are derived from the 2024 Finance Note itself. As Lord Verderami highlighted earlier, £20,000 is the sum that the United Kingdom agreed to pay for each relocated individual transferred to Rwanda under the agreement. We see this at paragraph 2.3.4. On this basis, Rwanda says that is a reasonable proxy for the basic initial cost of housing each individual in Rwanda. Indeed, in all likelihood, it severely underestimates that cost. Then 300. That is the number of refugees that were intended to be transferred in year one of the parties' arrangement. This is clear from paragraph 2.3.2 of the 2022 Finance Note at Exhibit C15. In Rwanda's submission, it is reasonable to assume that the parties would have proceeded on a reciprocal basis and resettled the same number in the United Kingdom over the lifetime of the partnership. In its statement of defence, the United Kingdom was extremely dismissive of Rwanda's numbers. It criticised Rwanda's approaches based on pure speculation. It offered these criticisms without even attempting to identify alternative figures or an alternative methodology. The key points in response are these. Let me start with the number of 300 refugees. The first point is that Article 19 refers to a portion of Rwanda's refugees being resettled. The use of the word portion shows that this was a substantial commitment. It indicates that what the parties had contemplated was a proper percentage rather than a small, merely symbolic number. This is consistent with the ordinary meaning of the word portion. The second point is that the figure of 300 is generous to the United Kingdom. It is a very small number compared to the overall population of 130,000 refugees that Rwanda has. Indeed, it is less than 1%. It is also a small number when compared with the number of Rwandan refugees that were resettled in third countries in the relevant period. In 2024, for example, the United States resettled over 3,300 Rwandan refugees, whereas Canada resettled over 600. We see this in the Rwandan government's figures at Exhibit C39. The United Kingdom itself has resettled nearly 3,800 refugees under the UK resettlement scheme since March 2021, as Exhibit C40 makes clear. The third point is the fact that the United Kingdom only relocated 4 individuals under the MEDP does not matter. Between April 2022 and March 2026, the United Kingdom was committed to resettling a portion of Rwanda's vulnerable refugees. That commitment was initially non-binding in the Memorandum of Understanding for the first 2 years, and then in a binding treaty for 23 months. Rwanda showed enormous goodwill towards the United Kingdom throughout this partnership. The fact that, because of court processes first and a political change of direction later, the United Kingdom has not relocated more individuals to Rwanda is simply a matter for the United Kingdom. What matters for Article 19 is that for 4 years, under successive British governments, the United Kingdom said it would accept vulnerable refugees from Rwanda. What has the United Kingdom done to honour these commitments? Nothing. How many refugees has it taken? None at all. In these circumstances, for the United Kingdom to reject the fair proxy figure of 300 relocated refugees without even proposing an alternative is a matter of genuine surprise and regret. That brings me to the figure of £20,000. The United Kingdom's only point on this is that the figure is not a reasonable proxy for Rwanda's expenses because this is an amount payable under the ETIF stream. If the United Kingdom prefers, the Tribunal could deploy the figures under the Asylum Processing and Operational Cost Funding stream of the Finance Note. Under paragraph 2.4.4, the United Kingdom agreed to pay up to a maximum of £150,874 per refugee over a 5-year period. Rwanda selected the figure of £20,000 because it represented a more modest and more accurate representation of the initial expenses to which Rwanda would be put for each refugee. But it is very happy to rely upon the higher figure if the United Kingdom would prefer. Absent any other indication from the United Kingdom on either the number of refugees or the costs associated with them, we respectfully invite the Tribunal to proceed on the basis of Rwanda's assessments. Alternatively, as we indicated in paragraph 23 of the reply, 63, I apologise, of the reply, it is open to the Tribunal to order the parties to negotiate arrangements for compensation commensurate with any breach of Article 19 established by the Tribunal. It may be useful to recall that in the notice of arbitration, Rwanda initially sought an order that the United Kingdom be directed to commence the good faith negotiation of the arrangements set out in Article 19. The United Kingdom then having filed its notice of termination, Rwanda recognised that negotiations under Article 19 would no longer be appropriate, and for that reason it sought compensation, alternatively an apology. But given that the United Kingdom has dismissed both of Rwanda's claims for relief in its statement of defence, Rwanda included this alternative provision in paragraph 63 of the reply. This was a specification of Rwanda's relief in paragraph 111I of its statement of claim. Rwanda, for its part, is open to negotiate with the United Kingdom on the appropriate modalities for compensation. What is important to Rwanda is that this serious breach of the United Kingdom's obligations sounds in more than declaratory relief. Mr. President, members of the Tribunal, that is the basis for Rwanda's compensation claim. Let me then turn to the alternative claim for an apology. As this Tribunal will appreciate, this is a recognised form of satisfaction. The United Kingdom's only real point in response is that it is rarely ordered. The real question, we say, is whether it is appropriate in this case. Rwanda submits that it is. Article 19 was a key part of the bargain concluded between the parties. It was part of the benefit conferred on Rwanda for its agreement to resettle a significant population of refugees from the United Kingdom. Rwanda firmly considers that it was wrong of the United Kingdom to renounce that obligation while the agreement remained fully in force and would remain so for another 12 months, simply because its own domestic assessment of the agreement's political convenience had changed. Rwanda is rightly aggrieved by the United Kingdom's conduct and seeks an apology. This case is unlike other cases referred to by the United Kingdom where the International Court of Justice did not order an apology. The underlying principles of Article 19, humanitarian assistance to refugees and burden sharing between developed and developing states, are fundamental to the proper and fair functioning of international law and the international refugee system. The United Kingdom's dismissive disregard for these principles, which is evidence in their position in these proceedings, warrants an apology. Rwanda also invites the United Kingdom to make a special contribution to the UNHCR's programme in Rwanda. This is in recognition of Rwanda's continued commitment to hosting a significant refugee population, despite the United Kingdom having unilaterally brought their partnership to an end. That is not a remedy requested from the Tribunal, but rather an appropriate political gesture that Rwanda would appreciate. Mr. President, members of the Tribunal, that is Rwanda's case in opening on Article 19. I just have a very few brief remarks on remedies in respect of Article 18 and the finance note, which shouldn't take more than a few minutes. As I notice, it's 12:59.
Okay, you can still proceed. As I announced at the opening that in case of need, you may slightly exceed 1 o'clock.
Thank you very much, Mr. President.
And also coffee break was a little bit longer.
So let me then turn to make a few very brief remarks about the relief that Rwanda seeks for the United Kingdom's breach of Article 18 and the finance note. Rwanda claims three things. First, a declaration of the United Kingdom's indebtedness to Rwanda in respect of both the Year 2 and Year 3 payments that are due or will shortly be due. Second, a declaration as to the United Kingdom's breach of Article 18. And third, an order that the United Kingdom pay all outstanding sums due to Rwanda. The United Kingdom takes the view that these declarations and this order should not be granted. We see that at paragraphs 201 to 202 of their Statement of Defence. This is because the United Kingdom says it has not breached either Article 18 or the 2024 finance note. As a result, it says no remedies should be granted. The United Kingdom, however, does not take any issue with the suitability of those remedies in the event that Rwanda succeeds in its case on breach, either under the 2024 finance note or under Article 18. For the reasons Lord Verderame has explained, the United Kingdom has breached both of those provisions. Rwanda is thus entitled to the orders that it seeks. With that, Mr. President, members of the Tribunal, Rwanda concludes its submissions in opening, and I thank the Tribunal very much for its kind attention.